The rendition that rendered justice impotent, why Nnamdi Kanu's trial must end now. In the annals of legal infamy, few phrases carry the moral weight of extraordinary rendition. The term, coined in the post-9/11 era to describe the CIA's practice of kidnapping terror suspects and flying them to black sites for torture, has now found an unlikely echo in Abuja. Only this time, the victim is not a bearded jihadist, but Mazi Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, and the perpetrator is the Nigerian state itself. Bruce Fein, Kanu's American counsel and a former U.S. Associate Deputy Attorney General, has just fired a legal missile into the heart of Nigeria's Federal High Court. In a letter dated October 28, 2025, Fein demands that Justice James Omotosho dismiss all charges against Kanu for a reason so elementary it should embarrass every law student in the country. A court cannot acquire jurisdiction through its own crime. The facts are no longer in dispute. In June 2021, Nigerian agents, in brazen violation of Kenyan sovereignty, abducted Kanu from Nairobi, bundled him onto a plane, and deposited him in Abuja like contraband. A Kenyan high court later ruled the operation illegal. The United Nations Working Group on Arbitrary Detention, in a 2022 opinion, catalogued the abuses: kidnapping, torture, enforced disappearance, and ordered Kanu's immediate unconditional release. Nigerian appellate courts have repeatedly affirmed that the rendition was unlawful. Even the federal government's own lawyers no longer pretend otherwise. They simply argue that the end, Kanu's trial, justifies the means, state-sponsored kidnapping. This is where Fein's letter becomes a masterclass in moral clarity. Quoting U.S. Supreme Court Justice Louis Brandeis's 1928 dissent in Olmstead v. United States, he reminds Justice Omotosho that if the government becomes a lawbreaker, it breeds contempt for law, it invites every man to become a law unto himself, it invites anarchy. The principle is not American, it is universal. From the Roman maxim ex injuria jus non oritur, law does not arise from injustice, to the Nuremberg rejection of superior orders, civilized jurisprudence has always held that a state cannot poison the well and then drink from it. Yet Nigeria insists on sipping. The Department of State Services, DSS, has held Kanu in solitary confinement for over 4 years, defying multiple bail orders. The trial has ping-ponged between judges, Justice Bintanyako to Justice Omotosho like a hot potato no one wants to drop. Each adjournment is sold to the public as justice in progress. In truth, it is justice in paralysis. Even if ESN is violent, which many doubt because there was no evidence provided to the court in regards, the rule of law is not a buffet. You do not get to violate extradition treaties, torture a defendant, and then demand he receive a fair trial in the same breath. As Fein warns Omotosho, continuing the case would implicate the court in the original crimes, exposing the judge to prosecution before the International Criminal Court. Hyperbole? Hardly. The Rome Statute recognizes enforced disappearance and torture as crimes against humanity when committed as part of a widespread or systematic attack. Nigeria's conduct fits the bill. The deeper tragedy is what this farce teaches Nigeria's youth. In the southeast, where Kanu's detention has fueled a sit-at-home, the message is clear. The state will break its own laws to silence dissent. When gunmen enforce IPOB's edicts with AK-47s, they are merely mimicking the lawlessness they see in Abuja. As Brandeis warned, crime is contagious. There is a way out, and it is staring Justice Omotosho in the face. Dismiss the charges, not because Kanu is a saint, he is not, but because the court's legitimacy is worth more than any conviction built on kidnapping. What it cannot do is continue this charade without shredding the last pretense of constitutionalism. History will judge Justice Omotosho by the choice he makes. Will he be the judge who upheld the principle that no government profits from its own criminality? Or will he be remembered as the magistrate who laundered a kidnapping into a conviction? The law has already answered. The only question is whether Nigeria still believes in it. Family Writers Press International,